That's
warm. I think we'll
literally and figuratively.
It will become warmer.
Warm enough.
That possibly, my lords, may not be aware.
Yes.
Lord, something before your lordship is assembled, my lord. The past, my lord. Lord, my respectful submission is, this is a pre-constitution statute, and whatever is extinguished cannot be tested on the ground of fundamental rights which came after the constitution. And for which, my lord, I have two illustrations to give.
Yes.
Yes. Lord, even during the British era, pre-constitution era, where the British legislature used to legislate for the purpose of universities, whenever the legislation felt that we must recognize and incorporate the founding events, they have so done. Lord, that illustration I wish to give. Lord, unless, because my lord, the argument of the petitioner was that while reading the statute, you have to go behind it to know kind of genesis, the word which was used, or that finding moment, the founding moment. No, that is not so. Unless legislation recognizes, the statutes take over from that date, and it is that complete code which governs the future course of action for that university.
Yes.
Lord, my submission is restricted to incorporation of universities, those statutes, my lord, not statutes in general. Please, my lord, allow me to place before your lordships volume 4I, page 535. How the past is statutorily recognized by the British Parliament. 4I, page 535 minutes. But it starts at 538. It is Annamalai University Act. So the purpose is to point out to your lordships and assist that whenever the legislature intended that we must recognize the founding event, they do so by way of a legislative enactment. The parties cannot request the court to go behind it, because behind it, there can be two views. I say it was not founded by XYZ. Somebody may say it was found by ABC. Somebody would say it was found by DYF. So therefore, the legislative device in case of incorporation of university, pre and post constitution both, is this. My lord, kindly have a look at page 538. Annamalai University, your lordships have?
Yes, we have the act.
But this is Annamalai University Act 1929. So it is a pre-constitution act.
28 or 29?
Section. Yes.
Yes.
Lord, please see an act to establish and incorporate a teaching and residential university at Annamalai Nagar. Whereas it is desirable to establish a teaching and residential university for the encouragement of higher education in research in Tamil Nadu districts, so and so. Now, please mark this, my lord. And whereas the Honorable Diwan Bahadur Sir SRM Annamalai Chettiar has established and is maintaining colleges at and near Chidambaram in which higher instruction is imparted in English, Tamil, and Sanskrit studies. And whereas Sir Annamalai Chettiar has agreed with the local government to hand over the said institutions uh, together with all properties attached thereto, and further to give a sum of 20 lakhs of rupees for the purpose of establishing and maintaining at Annamalai a teaching and residential university wherein he and his heirs shall be entitled to certain powers and privileges. But please see 2C. The term founder is defined. But it is at page 539.
Yes.
Founder, 2C. Lord, founder means the Honorable Diwan Bahadur Sir SRM Annamalai Chettiar, and after him his son, Mr. M.A. Muthaiya Chettiar, and for all time after the lives of the said two persons, in respect of every vacancy, any adult male member chosen by the Chancellor from amongst the members of the said Sir Annamalai Chettiar's family, consisting of his other sons and his descendants, tracing their descent through males, and if no such member exists, or if one such exists and he does not consent to act as founder, or if no such member is competent in the opinion of the Chancellor to act as a founder, then and until such a competent member comes into existence, is willing to act, or one who was not competent becomes competent, etc., etc. I'm not reading it, but this is how the founder is statutorily recognized. That's the only legislative way the British Parliament used to, my lord, act. Now, please come to section 8, my lord. The following shall be the officers of the university, namely the Chancellor,
Yes.
the founder. Rest are not relevant, my lord.
Yes.
And please, my lord, come to section 11 at page 544.
So, Sir Annamalai Chettiar would be the founder for life. He would hold the office of founder for life.
As recognized by the statute
By the
itself.
statute. You got the point.
So the court in future will never be required to undertake the exercise of going into the genesis of founding moment, etc.
Interestingly, what happened post independence to these statutory provisions?
Lord,
I mean, it's not relevant to your argument, but just as a matter of curiosity.
it was deleted post 2017.
So until 2017, that
17 it
continued.
continued. No, where is that act? No, it's 2013 Act, my lord. That's the amending act, page 1458
Page
of the
one.
same, Lord.
145.
145.
Nothing else in this act that you want to show us, right? So otherwise we had
Section 11, my lord.
section 11 we saw.
Is 544.
That we saw.
Your lordship have said 1458, my lord. Just to answer my lord's query, we have placed that on record.
That's the 2013 act.
Yes.
Let's just see it.
My lord, the entire act is now, a new act has come into force.
Oh, I see.
And there is no, my lord, founder.
Oh, they brought in a new act in 2013
Yes.
to replace.
So-
So right until 2013, that
That
hereditary-
continues, the member of the Chettiar
hereditary
family.
founder continued in Annamalai University.
And that founding fact and name of the founder was recognized. Whatever he must have bargained with the government, that was also recognized. He would be a member, he would be a part of the term officers. And my lord, my learned senior my lord wants me to see short page 12 also, my lord. I'm sorry, section 12. Please come to my lord, page,
12 of the
Oh, yeah.
repeal there?
the original,
Lines of time.
1929, my lords.
To rise for 2 minutes today at 10:59 because it's Martyrs' Day.
Yeah, yes.
But I heard the siren go off. It's just 10. Anyways, whether the siren goes or not, we'll all rise at 10:59.
No, whenever your lordship rises, we will. So section 12. The Vice Chancellor. The Vice Chancellor shall be appointed by the Chancellor from a panel of 3 persons recommended by the founder. This is administrative control also, apart from the fact of establishment. He is not only a member of the term officers,
Persons recommended by the
In pre-independence India, there were statutes which did recognize the role of the founder in establishing the institution, even post the enactment of the legislation by the imperial legislature. That's the point which you're trying.
and if he wanted a role in the administration,
Which
also,
is, according to you, absent in the case of the
present
Aligarh
AMU,
Muslim University.
a similar thing happened, my lord, with Visva-Bharati Act. My lord, I stand corrected. My lord, my instructions are, there was no degrees being given by Visva-Bharati, Shantiniketan, my lord. But when the act came into force post-constitution in 1951, my lord, I could get it, my lord, during the, my lord, I have shared it.
They'll upload it on the visualizer. वो upload कर दीजिएगा.
Only one para is to be seen. That there is a statutory device where founding fact, founder member, and what the other side says genesis is recognized by way of a statutory enactment itself.
What do we find in the Visva-Bharati Act?
Yes, my lord. It is. It was founded by Rabindranath Tagore. Thakur. That's mentioned in section 2 itself. Section 2, my lord, is on the screen. Declaration of Visva-Bharati as an institution of national importance. First is, this act may be called Visva-Bharati Act. It shall come into force. I skip. Declaration of Visva-Bharati as an institution of national importance. Whereas the late Rabindranath Tagore Thakur founded an institution known as Visva-Bharati at Shantiniketan in the district of Birbhum in West Bengal, the objects of which are such as to make the institution one of the national importance, it is hereby declared that institution known as Visva-Bharati aforesaid is an institution of national importance and is as such hereby constituted as a university. So two things happened. The founding person is statutorily recognized and university is established by an act of Parliament. Your lordships would find it was made university in 61. Otherwise, it was an institution of national importance. The footnote, my lord, makes it clear. My lord, I just now got, my lord, the original constitution. That is my respectful submission. Lord, I have got the constitution of original Visva-Bharati, but I got it in the morning only, my lord. I will go through it and place it on record. If there is something to be highlighted, my lord, I'll request one of my learned, my lord, senior colleagues, my lord, to highlight, because my turn would be over. I don't wish to, my lord, come again. My lord, now, my lord, may kindly see. So, my lord, my respectful submission is that in absence of this founding event, or what they call genesis, etc.,
if you take your submissions that absent a statutory recognition of the founding moment, the statute therefore obliterates the entire past
and takes over
and begins on a clean
as
slate.
a complete code. And that is the statutory device adopted by the legislature both pre and post constitution. My lord,
Solicitor,
my lord.
in the absence of an express obliteration of the past by the statute, can the court not look into the pre-existing history unless we find that there are certain express provisions in the statute? I mean, I'm just putting you the flip side of it so that, to elicit a response. Absent an express obliteration of the past by the statute, is there something in law or constitutional law to prevent the court from looking at the circumstances which led to the creation of that university or the creation of that institution by a statutory provision?
My lord, my respectful answer, my lord, would be no. The simple reason is, my lord, that history always has several shades. My lord, absent Annamalai part, my lord, in the act which I have shown. My lord, suppose that would not have been taken care of, my lord, or recognized by the statute. There may be 5 versions of history that not Mr. Sir Annamalai, it was Sir Chettiar also who was running. It was not Sir Annamalai, it was somebody else also who contributed money. It
In
was
other
not
words,
Sir Annamalai,
I got your
the
point.
entire.
In other words, could it be like this? Could it be your submission, therefore, that unless the statute expressly recognizes the minority character of an institution, you cannot claim the right? Would that be, can we stretch it to that point?
Lord, I would not say minority character. I would say for any university, the founding event, founding members, and founding facts, whoever is saying whatever, unless recognized by the statute, if it becomes a statute, the statute is the final word. It would not be possible for any party to request the court to go behind it and try and find out the history.
That's why you have sort of distinguished the case of Annamalai and
Yes. And that would be so about even majority institution. I do not know, Annamalai may even be a majority institution.
Annamalai non-property is it's not an Article 13.
No, my lord, maybe a linguistic minority, I'm not aware of. Maybe a linguistic, may not be a linguistic, but whenever any university incorporated under an act, unless that's, my lord, therefore I have shown. And I'll show, my lord, other university similar examples.
Fair enough, you have made the point. Now
Yes.
we can go to the next
Now,
point. We'll have
your
to
lordship,
require
my
answer
lord,
for
kindly come to volume 4C, page 1346. My lord, this is debates of the year 1972. My lord, I have already.
Same 15.
that.
volume 4, reassembly. Even if, my lord, history is to be gone into, so there are two sets of histories before your lordships, my lord. I have given a different my lord, list of dates and events. The question would be, Lord, how would your lordships examine? I'm posing a question to myself. Which part of the history is true? Therefore, my lord, even from the prudence test, the submission which I'm making, that whenever statute recognizes or wants to recognize by a legislative enactment the founding events, Lord, it would be final, and the statute takes over, it becomes a complete code. Now, your lordships may, my lord, kindly allow me to place volume 4C, page 1343, my lord. Lord, this is the speech before the House by Professor S. Narul Hassan, who was the Minister of Education and Social Welfare in 1972 when amendment was introduced.
Page 1343.
Yes, 1343. What your lordships would recall, there was an amendment in 1972 in AMU Act. And I'm just showing, my lord, who is speaking, my lord. The concerned minister, my lord, this is the stand of the government. The Minister of Education, Social Welfare and Culture, Professor S. Narul Hassan. Please, my lord, see second unnumbered page on the right side column. What change was made? Earlier, your lordships are aware. 1343, volume 4C, my lord.
C, okay.
Yes, ma'am. Lord, I may not take your lordship's time. I'll just orally say.
No, you can just show it to us. We are already on it.
Yes. Formally, the chancellor was elected by the court. Your lordship knows the court then, when it in 2020 was consisting of Muslims. We are now proposing that Chancellor shall be appointed by the visitor in such a manner as as is provided in the statutes. And in the statutes, it is suggested that out of panel of 3 names, the visitor may appoint the Chancellor. The Chancellor should be able to exercise his moral authority in the best interest of the university and should not in any way be associated with any group or faction. Therefore, he would be above all decisions, because he will not be a party to any of the decisions. So he is not dependent upon the votes of the court. Now, my lord, more important part is at page 1346. And in my respectful submission, after this, no debate, my lord, from the petitioners can survive in the present matter. This is the stand of the government through the Honorable Education Minister while amending the Act itself. Your Lordship, my lord, has page 1346. My lord, right-hand side column, last 2 paragraphs. My lord, it starts with, it would not like. I would not like. Does your Lordship get, my lord? So this is what the government says in Parliament, because there were demands that you declare this to be a minority university, and the minister answers, I would not like to take very much more of the time of the House, except to refer to 2 or 3 points which have been raised. First of all, a demand was raised that this university should now be declared to be a minority institution in terms of Article 30, Sub-Article 1 of the Constitution. Sir, this is a demand which is neither in the national interest nor in the interest of the university itself. Nor, if I may venture to suggest, of any section of our population, including the Muslim community. The responsibility for the educational development of every section of the population has been taken by the state. Maybe it is some part of it with the union government and the other parties with the state government. If the educational development of the entire country and all sections of the population is to be ensured, it would be necessary to see that the state plays its due part. Any single institution cannot be maintained by the central government for the benefit exclusively of one community or to be run by a single community. Till 72, there was a demand that you declare it to be a minority institution. And for very valid reason, with a foresight, looking at the future, not a very eminent educational minister made this statement that it is not in the interest of the nation, nor in the interest of the community. So, my lord, after this, in my submission, my lord, the issue is closed. That's my respectful submission. My lord, similar, kindly come to debates of 1981, same volume, page 1680.
Same volume?
Yes, my lord, 1680. My lord, this is the bill which, my lord, your lordships may recall, introduced. The word establish was deleted. And definition was added as a post facto approval of one-sided history. Well, I'm not going into the merits or demerits of 81, but I wish to read, my lord, what transpired in the Parliament. Lord, kindly come to 1680. These are the debates when 81 amendment was introduced. Shri G.M. Banatwala, your lordship, sir. Mr. Deputy Speaker, sir, the Honorable Minister has been kind enough to tell the House that it was one of the pledges of the ruling party to restore the minority character of Aligarh Muslim University, and this bill seeks to fulfill this pledge. I, on my part, respect the sentiments of the government, but I wish that the provisions incorporated in the bill had really led to fulfillment of the pledge. Mr. Deputy Speaker, sir, the government, as we understand now, wants to restore the minority character of Aligarh Muslim University. Well, kindly pause here as a factual thing. The government never wanted to restore. It has said in 72 that it cannot be given. Something can be restored if it existed at any point of time. Be that as it may. Then why does it fight shy of saying so in the bill itself? Why should there be reservation? There are certain basic things which need to be understood. We are not playing with words. Those who are not capable of understanding the words are totally incapable of understanding the ideology and the facts behind this. There are show boys who have brought great woes and pains to this country. I have only to tell the government not to practice self-deception. The main issue is the restoration of the minority character to the Aligarh Muslim University in such a manner that the university gets protection of Article 30, Sub-Article 1 of the Constitution. The university has to be recognized as an educational institution as envisaged under Article 30, Sub-Article 1 of the Constitution. I'll skip the quotation. The judgment in Aziz Basha's case is a standing injustice both to the provisions of our Constitution as well as the minority and the secular concept that we have in our country. In this case, the Supreme Court has erroneously made an observation that the university has neither been established by Muslims nor has the administration of the university been ever exclusively vested in the minority in Muslims. Therefore, there are two aspects of the question. Please mark this, madam.
Yes.
He is demanding now that all right, you have established by incorporating the word, by deleting the word established. You are taken care of according to his understanding, not subject to that act being challenged. Now give us the administration also. So therefore, I am reading it. And the minister says no, administration cannot be given. So even as per this debate in Parliament, nothing survives. Lord, I am on page 1680, the bottom side top. Therefore, there are two aspects to the question. Your Lordship's get. One aspect is the aspect of establishment of the university. This bill clearly says that it has been established by Muslims. Your Lordship would recall the definition of university is changed. That's what he is referring to. We are thankful to the government. I congratulate the government that the government has come forward with a recognition of this historical fact. But then the other aspect remains, and that aspect is that since allegedly the administration of the university never exclusively vested amongst the Muslims, therefore it is not an educational institution envisaged under Article 30, Sub-Article 1 of the Constitution. He admits that unless I have the administration, I can't rely upon 30 Sub-Article 1. The position should therefore be clarified. The definition as given of the term university in the present bill, which is now before the House, does not fully meet the requirements of Article 30 Sub-Article 1 of the Constitution and does not fully set at naught the observations of the Supreme Court in Aziz Basha case. Therefore, it is that we have come before the House to clarify explicitly that Aligarh Muslim University is a minority institution within the meaning of the minority institution under Article 30. Now directly come to the reply of the Honorable Minister at page 1682 on this question. The request, the demand that administration should also be given to us. It admits there is no administration with us, and the Honorable Minister 1682 right hand side, my Lordship, get Srimati Sheila Kaul. I'm sorry, I may just before that, a page before that. 1681, just right hand side, there was a suggestion to add an explanation.
Right, right. I saw that actually.
notwithstanding any judgment, decree, etc., my lord, which was not accepted by the Parliament. Now, please come to 1682. Srimati Sheila Kaul, my lord, she was the education minister.
No.
The Lord Srimati Sheila Kaul, as an education minister, answers on the question of administration. As the university will be administered in accordance with the provisions of the Act, statutes, and ordinances, it is not possible to agree to the amendment moved by Shri Banatwala, and the amendments are not therefore acceptable. My lord, the amendment which was moved is, Lord, please see, lobbies have been cleared. The question is to be administered by the Muslims of India. The Lok Sabha divided, my lord, and this
Mr.
amendment failed.
Minister, can you just show us that little when Mrs. Kaul moved the bill? What was the purpose? Because when she introduced the bill, she may have clarified why she was moving the bill. Can you just see that part so that
Yes,
since
yes.
otherwise, you know, to go to it later,
Yes,
maybe just
I'll just, my lord, in a second.
1154.
one.
154.
No. Wait. No, not this one. I'll read this also. But there is some else. I have marked it.
What's asked about who moved and what was moved. What are the main things that was structured?
So can your lordships come to 1590? This was, my lord, thereafter referred to the standing committee.
Just come to 1155.
154 and 55, yeah.
1155.
1155.
55.
Lord, shall I?
It is a pledge that we seek.
It is the pledge that we are seeking to redeem today. It was a pledge that we gave to our Muslim brothers. The establishment of Aligarh Muslim University Act was an important landmark in the development of modern education of Muslim of India. However, it was not the point at which the history of the Aligarh Muslim University started. As far back as 1870, Sir Syed Ahmad Khan realized that modern education was the only means for removal of backwardness of the Muslim community in India. At his initiative, a committee to devise ways and means for the educational regeneration of Muslims was set up. 2 years later, sir, a society called the Mohammedan Anglo-Oriental College once started. Well, then the history. May I read, my lord, history again, my lord? One side history is given, my lord. The second side history, that you started negotiating with the government and started giving up one thing after the other, is not recorded. And countered by Sri Somnath Chatterjee. But if your lordship wishes me to read, I can read, madam.
Just a little bit, we'll just see what she
Yes,
was saying.
I'll just. One of the steps taken by the society was to open a school in 1973. There, 3 years later, sir, it became a high school, and in 1977, the foundation stone for the establishment of a college was laid. Sir Syed Ahmad Khan died in 1880. It should be 1877 and 1873. 1880. But the idea of establishing a university gathered strength even after his death. The Muslim University Foundation Committee had started collecting funds for setting up the university. The MAO College Aligarh had by that time grown into a leading center to the education of Muslims. After prolonged discussions extending over 6 years between the Government of India and the representative of Muslim University Foundation Committee, the Aligarh Muslim University Act with Mohammedan Anglo-Oriental College as its nucleus was passed. Well, there the history is not given, that there were continuous correspondence that this is the condition, take it or leave it. This is the condition, take it or leave it. That is not given, Manoj. Sir, 1920 enactment was the realization of the long cherished ideals of the Muslims of India, and it was their dream that found expression in the establishment of this university, and the substantial part of the properties and funds which went into making was also contributed by them. Sir, these are the facts of history which we must recognize and acknowledge. For quite some time, the Muslims of India have been expressing concern that the law governing the Aligarh Muslim University does not recognize or acknowledge these historical facts. Therefore, there has been a unanimous demand voiced by the Muslims of India that the Aligarh Muslim University, as it stands today, should make provision for the acknowledgement of this fact. This demand has the support of all sections of the country, including all political parties. Sir, the Aligarh Muslim University today is one of our largest residential universities. It is a composite institution offering education from the nursery stage to the highest level of research. The courses offered by the university cover all major disciplines: engineering, technology, medicine, science, social science, and humanities. Something I'm respectfully basing my submission on this as well. No?
It's clear that the object of the government of the day in introducing this 1981 bill was to recognize, as the Union Minister said, a historical fact that it was established by the Muslims of India. That we can't. That seems to have been the.
I also can't wish away. But before that, she says that this was a part of our election manifesto. And your lordships, I leave it at that. Your lordships may realize the danger if the parliament were to be permitted to recognize 100 years history, hundreds of years of history. I leave it at that, my lord.
That is Parliament's exclusive domain. We can't.
I'm happy. I'm very happy.
The policy underlying the.
I am very happy. I'm very happy. I'm arguing only university matters, but Parliament deals with many historical facts. I'm very happy.
Subject to constitutional validity, of course.
Of course. But therefore, I didn't want to elaborate much on that.
So what stands out is one of the honorable members, Mr. Banatwala, wanted a clarification to be inserted in the act that this is a minority institution.
Yes.
But there the honorable minister said no, administration would be according to the statutes and the ordinances. Therefore, administration part cannot be left with a particular committee.
Yes, my lord, coupled with the fact that Mr. Banatwala says that unless you give us administration, we cannot fall under 30.
Only establishment part was so to be recognized, but
Yes.
administration part was refused.
Was categorically refused.
But then when was for the first time the institution was recognized by the government as a minority institution?
But this was never recognized.
It's one thing is very clear. The intent behind the 81 amendment was to recognize and give it as a minority institution and to do away with whatever the reasoning was given. The attempt was to modify the reasoning given or make the statute, modify the statute so that the reasoning given in Basha's case is not applicable. Yes.
Is this not that? After half an hour also it rings?
No.
No.
Administration is concerned, yes, Mr. Banatwala did say that please make an amendment saying its administration is the Muslims. That the government did not agree. But what they said, administration is already provided in the statute.
Statute, yes.
No, all statutes will provide for administration. Even today, even after the 2004 Act, the Education Act, minority, each statute will provide for administration. That's not the administration, the word, mainly because the statute provides for administration is cannot lead to a finding whether it's a minority or a majority.
No, Lord, I would risk.
If we accept that argument, that if administration is provided by the statute and this itself is going to be a ground to decide whether its institution is a minority or majority or non-minority institution, will lead to difficulty.
I'll just, my lord, respectfully, my lord,
How
answer.
can that be mainly because administration is provided by the statute? That is may not be the criteria.
Kindly.
We have to find out who are the people actually administering it,
Correct.
or in terms of the statute, who are the people entitled to
I bow down, my lord. Your lordships will have to examine the statute as it stood in 1981, and in that context, my lord, examine the request of Mr. Banatwala that right now it is not our administration. And therefore, we are unable to fall within the second part of Article 30, Sub-Article 1. That establishment, yes, but not administered by us. You clarify that we are administering also. She says, no, Act will govern.
Whether,
And the amendment,
whether the government was right or not, that's a separate issue. But the fact of the matter is, the government also, when they were saying it's a minority institution, they very well knew of the requirements of Article 31. They felt that the administration is also with the minority,
no, my lord.
because otherwise they will not say it's a minority institution.
No, my lord, they didn't. I'm sorry.
Mr. Solicitor, they were very well aware the two requirements for minority institution: establish and administer.
Correct, my lord.
To say that when they moved the amendment and made an open statement in the House of the Parliament saying it's a minority institution, they were not aware that administer is also one of the requirements, will be little difficult to accept. Maybe they may be right or wrong. It's a separate question.
Yes, my lord, maybe they are consciously, my lord, did that. All right, we satisfy you. We recognize the historical fact. What they have done is recognizing the historical fact according to their history, without, my lord, or rather omitting the history which I have shown. That one after the other, they started, my lord, giving up their rights. If there was no concept of a right, but their demands, their insistence, that this we will not accept, all right, we give up. This we will not accept, all right, we give up. That's not taken care of. But they say that we recognize a fact in history that this is what happened. As my lord, I'll not reread it. But everyone was clear, including the government, but especially Mr. Banatwala, that unless you give it, and what was, my lord, the amendment suggested? Amendment was administration to be given to Muslims. That was within inverted comma. And the minister says, no, it will be as per the Act. If as per the Act, your lordship finds that it was Muslim administration, that's a separate thing. But if that is so,
Solicitor, to really conceptualize your argument, because I think we've heard you on this, your argument is that Article 30 incorporates twin tests: establishment and administration. Basha came to the conclusion that, well, one, Aligarh Muslim University was not established by Muslims, though it does recognize the history of Anglo-Oriental College, etc., because it says it was established by statute. That's the first limb of Basha. And inasmuch as that it was established by statute, it has not been established by a Muslim minority. That's the first limb of Basha. Second, Basha says on the review of the Act that it is not administered by the Muslim minority. The 1981 amendment, according to you, was intended to recognize the historical fact of the establishment of Aligarh Muslim University and brought about that change both in terms of the preamble and in terms of the definition of the expression university. But the second limb of Basha, which was that it has to be administered by the minority, there was no alteration to the existing statutory provisions in relation to administration, and which was in fact noticed by Mr. Banatwala that you cannot, in that sense, though he didn't put it in that word, in those words, that you cannot override Basha unless you deal with both the establishment and the administration tests. And you had left the administration intact, and therefore it would not, in that sense, still fall within the ambit of 30.
Basha still stands, would stand.
And
that's what
that's your contention.
And Manoj, I'll just add
and
one.
Perhaps therefore your contention is that the 1981 Act did not take away the basis of Basha, because you could have taken away the basis of Basha by not merely recognizing but administration as well. That's your
plus
let me hear the other side in response. I think now we've understood it conceptually.
Basha also recognizes.
I think that is really the submission.
Basha also recognizes the fact that your rights, if at all there were any pre-constitution, were extinguished, because you started giving up those demands one after the other, and therefore there was no concept of a minority or minority rights in 1920. It was just a bargain between me and the government. Some of them, my lord, said that we will not accept your bargain. We will say that no, we want to have this framework. But those who were in charge, my lord, Mr. Sefi and led by them, my lord, they say, all right, we give up this, we give up this. Government says, no, it would be full control of the government. All right, we give, let it be government control, etc. My lord, I have given. Basha recognizes that, my lord, the parliamentary debate does not.
All right. Anything
My
now?
lord,
what's
next,
the-
my lord, next. Please come to page, my lord, volume 2A. I'll take only 10 minutes, my lord. 2B, I'm sorry, my lord, 2B. At page 50 to 54. I'm not going to read, but I just want to give, my lord, the illustrations.
Please, Mr.
50, my lord.
2B,
To
page 50 to
554. How, my lord, this factor